Dear students, Namaskar. We are here again to discuss the previous lecture. In our last lecture, we discussed one of the landmark judgments. It was the Islamic Academy Foundation case. This case was filed for the purpose of resolving the doubts arising in historic landmark judgment. It was TMA Pi Foundation case. Again, when the judgment delivered by the Honorable Apex Court in Islamic Academy case, it has been raised eyebrows by the non-minority unaided educational institutions and minority unaided institutions that this decision was not correctly interpreted the judgment of TMI Pi case. Here, the judgment was challenged on the ground of relevant articles under Article 19, Article 26, Article 29, and 30 of the Constitution. Here, this decision was decided or the bench of headed by Justice Chief Justice of India, Justice R.C. Lohiti, Justice Y.K. Sabharwal, Justice D.M. Dhramidghari, Justice Arun Kumar, Justice G.P. Mathur, and Justice Tarun Chatterjee, and Justice P.K. Bala Subramaniam. Means that this judgment was delivered by 7-judge bench of the Supreme Court. As all of you are aware, Islamic Academy decision was delivered by 5-judge bench of the Supreme Court. In this case, the petitioner raised the points that self-financing educational institutions like non-minority unaided educational institutions, minority unaided institutions, where the Supreme Court in Islamic case has fixed the quota ratio of government share, particularly for the purpose of catering the local needs, especially for the candidates belonging to the poor section and backward classes. So here the point was raised that appropriation of quota by state or reservation policy seat sharing states cannot insist on self-financing educational institutions to implement its reservation policies for granting admission to the less meritorious students. And here, the nationalization of seats disapproved. As we discussed, that nationalization of seats were binding for non-minority unaided educational institutions by the state, because they were raising the point that they are on the equal footing, but the Supreme Court held that they are not on the equal footing as compared to the minority educational institutions. In this seven judge bench, the Supreme Court has examined and explained the scope of judgment of PM Pai Foundation as clarified in Islamic Academy Foundation case, the extent of state control in the matter of admission to self-financing education institutions, and the admission and the fee structure to be formulated have been examined in depth, and the court disposing the batch of cases. First, the court held that so far as appropriation of quota by the state and enforcement of its reservation policy is concerned, we do not see much of difference between non-minority and minority educational institutions, especially minority and non-minority unaided educational institution. We find a great force in the submissions made by the petitioners that the state have no power to insist on seat sharing in the unaided private educational institutions by fixing a quota of state between the management and the state. The state cannot insist on the private educational institutions which receives no aid from the state to implement the state's policy of reservation for granting admission on a lesser percentage of marks, that is on any other criteria except merit, means that the admission should be made in these educational institutions on the basis of merit, not on the basis of any state quota or the reservation policies implementation of or enforcement of reservation policy led by the state government cannot be enforced. The observation opinion in it was raised that the observation opinion in Pi Foundation case, on which the learned counsel for the parties have been much at variance in then submissions, according to us, are not to be read disjointly or separately from other parts of the main judgment. A few observations contained in certain paragraphs of the judgment in Pi Foundation, if read in isolation, appears conflicting or inconsistent with each other. But if the observation made and conclusions derived are read as a whole, the judgment nowhere lays down that unaided private educational institutions of minorities and non-minorities can be forced to submit to seat sharing and reservation policy of the state. Reading relevant parts and the judgment on which learned counsel have made comments and counter comments, and the reading the whole judgment, in our considered opinion, observation in Time Pai merely permit unaided private educations to maintain merit as the criteria of the admission by voluntary agreeing for seat sharing with the state or adopting selection based on common entrance test of the state. There are also observations saying that they may frame their own policy to give free scholarships to the needy and the poor students, or adopt a policy in line with the reservation policy of the state to cater to the educational needs of the weaker and the poorer section of the society. So in TMA Pi case, nowhere in TMA Pi case, uh, either in the majority or in minority, uh, have we have not found any justification for imposing seat sharing quota by the state on unaided private professional education institution and reservation policy of the state or state quota seats or management seats. We make it clear that the observations in TMA Pi case mentioning fixation of percentage of quota are to be read and understood as possible consensual arrangement which can be reached between unaided private educational institutions and the state for the aforesaid reasons. We cannot approve of the scheme evolved in Islamic academy to the extent it allows states to fix quota for seat sharing between management and the state on the basis of local needs of the each state in the unaided private educational institutions of both minority and non-minority categories. That part of the judgment in Islamic academy, in our considered opinion, does not lay down the correct law and runs counter to Pi Foundation case. The Constitution of India under Article 19, 26, 29, 30 clause 1. In the light of all these articles, sorry, in the uh, in the light of Article 19, 26, 29, 30 clause 1 of Indian Constitution, self-financing educational institutions, procedure for admission, all institutions parting the same or similar professional education can join together for holding a common entrance test, provided it is fair, transparent, and non-exploitative. State can also provide a procedure of holding common entrance tests if private educational institutions fail to satisfy any of the triple tests indicated above. That means that in case if they fail to observe the fairness, transparency, and non-exploitative, then the state can make their interference. Then the state can take over the admission procedure and substitute with its own centralized single window permissible. In the light of these provisions, the Supreme Court held that, as per our understanding, neither in the judgment of Pi Foundation nor in the Constitutional Bench decision in the Kerala Education Bill, which was approved by the Pi Foundation case, there is anything which would allow the state to regulate or control admission in the unaided professional education institutions so as to compel them to give up a share of the available seats to the candidates chosen by the state as if it was filling the seats available to be filled up at its discretion in such private institutions. This would amount to nationalization of quota. This would amount to nationalization of seats, which has been specifically disapproved in Pi Foundation case. Such imposition of quota of states seats or enforcing reservation policy of the state on available seats in unaided professional institutions are acts educational institutions are acts constituting a serious encroachment on the right and autonomy of private professional educational institutions. Such appropriation of seats can also not be held to be a regulatory measure in the interest of the minority within the meaning of Article 30, Clause 1, which says that they have the right to establish and administer the educational institution of their own choice, or a reasonable restriction within the meaning of Article 19, Clause 6 of the Constitution, which may uh, which may lay down reasonable restriction for the purpose of the restriction, or for the purpose of not to give absolute freedom under Article 19, Clause 1, Clause G. Here, merely because the resources of the states resources of the states in providing professional educations are limited, merely because the resources of the states in providing professional educations are limited, private educational institutions which are intended to provide better professional education cannot be forced by the state to make admission on the available on the basis of the uh, uh, state quota or the reservation implementation of reservation policies. So unaided educational institution, as they are not deriving any aid from the state funds, can have their own admission if fair, transparent, and non-exploitative, and based on merit. In TMFI Foundation case, it has been very clearly held at several places that unaided professional education institution should be given greater autonomy in determination of the admission procedure and their fee structure. State regulation should be minimal and only with a view to maintain fairness, transparency, and transparency in admission procedure, and to check exploitation of the students by charging exorbitant money or capitation fee. Our answer to the first question is that neither the policy of reservation can be enforced by the state, nor any quota or percentage of admission can be worked out to be appropriated by the state in a minority and non-minority unaided educational institutions. Minority institutions are free to admit students of their own choice, including the students of non-minority community as well as members of their own community from the other states, both to the limited extent only and not in a manner and to such a extent that their minority educational institutions status is lost. If they do so, they lose the protection of Article 30, Clause 1. Whether minority or non-minority institutions, they may be more than one similarly situated institutions imparting education in any way, in any one discipline, in any state. The same aspirant seeking admission to the take education in any one discipline education shall have to purchase admission forms from several institutions and appear at several admissions tests conducted at different places on same or different dates, and there may be a class of dates also. So if the same candidate is required to appear in several tests, he would be subjected to unnecessary uh, unnecessary and avoidable expenditure and inconvenience. So there is nothing wrong in the entrance test being held for one group of institutions imparting same or similar education. Such institutions situated in one state or in more than one state may join together and hold a common entrance test, or the state may itself or through an agency arrange for holding of such tests. Out of such common uh, merit list, the successful candidate can be identified and chosen for being allotted to the different institutions depending upon the course of the study offered and the number of seats, the kind of minority to which the institution belongs, and other relevant factors. Such an agency conducting common entrance test must be one enjoying utmost credibility and expertise in the matter. So this would better and to ensure the fulfillment of twins objective of transparency and merit. Common entrance test is necessary in the interest of achieving the said objectives and also for saving the students community from harassment and exploitation. Holding of such common entrance tests followed by centralized counseling, or in other words single window system regulating admissions, does not cause any dent in the right of minority unaided education institution to admit students of their choice. Such choice can be exercised from out of the list of successful candidates prepared by the common entrance test without altering the order of merit inter se of students so chosen. The Pi Foundation case has held that minority unaided institutions can legitimately claim unfettered fundamental rights to choose the students to be allowed admissions, and the procedure therefore subject to its uh, being fair, transparent, and non-exploitative. So the same principle applies to non-minority unaided institutions also. There may be a single institutions uh, imparting a particular type of education which is not being imparted by any other institution, having its own admission procedure, fulfilling the test of being fair, transparent, and non-exploitative. All institutions imparting same or similar professional education can join together for holding a common entrance test, satisfying the above said triple test, that is fairness, transparency, and non-exploitative. So the state can also provide a procedure of holding a common entrance test in the interest of securing fair and merit-based admissions and preventing maladministration. The admission procedure so adopted by private institutions or group of institutions, if it fails to satisfy all or any of the triple tests indicated here in above, is can be taken over by the state substituting its own procedure. The second question is answered accordingly. It needs to be specifically stated that having regard to the larger interest and welfare of the student community to promote merit, achieve excellence, and curb malpractice, it would be permissible to regulate admissions by providing a centralized and single window procedure. Such a procedure, to the large extent, can secure grant of merit based admissions on a transparent basis. Till regulations are framed, the admission committee can oversee the admissions so as to ensure the merit is not the casualty. The Constitution of India. Now, here the Supreme Court also held that here itself we are indicated to deal with the question as to seats allocated for non-resident Indians, and that is sought in NRI. So, admission to unaided educational institutions, NRI quota limited reservation of 15% to be made available to NRI depending upon the discretion of the management. To prevent misutilization of such quota or any malpractices, suitable legislation or regulations held has to be framed. Until then, it will be for the committees constituted pursuant to Islamic directions to regulate. So, a limited reservation of such seats, not exceeding 15%, in our opinion, may be made available to the NRIs depending upon the discretion of the management, subject to two conditions. First, such seats should be utilized bona fide by the NRI only and for their children or wards. Second, within this quota, the merit should not be given a complete to buy. The amount of money, whatever from collected from such NRIs, should be utilized for benefiting the students, such as from economically weaker sections of the society, whom, on well defined criteria, the educational institution may admit on subsidized payment of their fee. So, to prevent misutilization of such quota or any malpractices referable to NRI quota seats, suitable legislation or regulation needs to be framed. So long as the state does not do it, it will be for the committees constituted pursuant to Islamic Academy directions to regulate. Now, the unaided educational institution fee structure. Every institution is free to devise its own fee structure, subject to the limitation that there would not be profiteering and no capitation fee can be charged in any form. So, the Supreme Court held on this point to set up a reasonable fee structure is also a component of the right to establish and administer an institution within the meaning of Article 30 of the Constitution, as per the law declared in Pi Foundation case. So every institution is free to devise its own fee structure, subject to the limitation that there cannot be no profiteering and no capitation fee can be charged directly or indirectly or in any form. Capitation fee cannot be permitted to be charged and no seat can be permitted to be appropriated by payment of capitation fee. Profession has to be distinguished from business or mere occupation. While in business and to the certain extent occupation, there is a profit motive. But in profession is primarily services to the society, wherein earning is the secondary or incidental. A student who gets a professional degree by payment of capitation fee, once qualified as professional, is likely to aim more at earning rather than serving, and that becomes a being to the society. So, the charging of capitation fee by unaided minority and non-minority institutions for professional courses is just not permissible. Similarly, profiteering is also not permissible. Despite the legal position, this court cannot shut its eyes to the hard realities of commercialization of education and evil practices being adopted by many institutions to earn large large amounts of their large amounts for their private or selfish ends. If capitation fee and profiteering is to be checked, the method of admission has to be regulated so that the admissions admissions are based on merit and transparency and the students are not exploited. It is permissible to regulate admission and fee structure for achieving the purpose just stated. Our our answer to the three question is that every institution is free to devise its own fee structure, but the same can be regulated in the interest of preventing profiteering. No capitation fee can be charged. Article 19, Clause 1, Clause G, Article 30 and Article 142 of the Constitution, uh, committee decision of the committee is found to be have exceeded its powers by unduly interfering. So here the Supreme Court held that the two committees for monitoring the admission procedure and determining the fee structure in the judgment of Islamic Academy are in, are in our view permissive as regulatory measures aimed at protecting the interest of the students community as a whole as also the minorities themselves in maintaining required standard of professional education on non-exploitative terms in their institutions. Legal provisions made by the state legislature or the scheme evolved by the court for monitoring admission procedure and fee fixation do not violate the right of minorities under Article 30 Clause 1 or the right of minorities and non-minorities under Article 19 Clause 1 Clause G. So they are reasonable restrictions in the interest of the minority uh, institutions permissible under Article 30 Clause 1 and in the interest of the general public under Article 19 Clause 6 of the Constitution. In our considered view, the Supreme Court held that in our considered view, on the basis of judgment in Pi Foundation case and various previous judgment of the court, which have been taken into consideration in that case, the scheme evolved of setting up the two committees for regulating admission and determining the fee structure by the judgment in Islamic Academy cannot be faulted either on the ground of alleged infringement of Article 19 Clause 1 Clause G in case of unaided professional education institution of both categories and Article 19 Clause 1 Clause G read with Article 30 Clause 1 in case of unaided professional institutions of minorities. If fortiori, we don't see any impediment to the constitution of the committee as a stopgap or ad hoc arrangement made in exercise of power conferred on this court by Article 142 of the Constitution until a suitable legislation or the regulation framed by the state steps in. Such committee cannot be equated with Unni committee, which were supposed to be permanent in nature. However, we would like to sound a note of caution to such committees that the learned counsel appearing for the petitioner have severely criticized the functioning of some of the committees so constituted. It was pointed out by citing concrete examples that some of the committees have indulged in assuming such powers and performing such functions as were never given or intended to be given to them by the Islamic Academy decision. So certain decisions of some committees were subjected to the serious criticism by the pointing out that the fee structure approved by them was abysmally low, which has rendered the functioning of the education institution almost impossible or made the institution run into the losses. So in some of the institutions, the teachers have left their jobs, left their jobs and migrated to other institutions as it was not possible for the management to retain talented and highly qualified teachers against the salary permitted by the committee. A retired High Court judge heading the committees are assisted by experts in accounts and management. They also have the benefit of hearing the contending parties. We expect the committees, so long as they remain functional, to be more sensitive and to act rationally and reasonably with due regard for realities. They should refrain from generalizing fee structure and, where needed, should go into the accounts, schemes, loans, and budgets of an individual institution for the purpose of finding out what would be an ideal and reasonable fee structure for the institution. We make it clear that in case of any individual institution, if any of the committee found to have exceeded its power by unduly interfering in the administrative and financial matter of the unaided private professional institutions. uh, the decision of the committee being quasi judicial in nature would always subject to the judicial review. On question 4, our conclusion therefore is that the judgment of Islamic Academy, so far as it evolves the scheme of committees one reach for admission and fee structure, does not go beyond the law laid down in by foundation case, earlier decision of this court, which have been approved in that case. So the challenge to setting up two committees in accordance with the decision in Islamic Academy therefore fails. However, the observation by way of clarification contained in contained in Islamic Academy, which speaks of quota and fixation of percentage of seats by the state government, is rendered redundant and must go in view of what has been already held by us in the earlier part of this judgment while dealing with question number 1. It is for the central government or the state government, in the absence of central legislation, to come out with a detailed, well thought out legislation on the subject. Such legislation is long awaited. States must act towards this direction. Judicial wing of state is called upon to act up when other two wings of the legislature and executive uh, do not act. So earlier the Union of India and the state governments act, the better it would be. The committees regulating the admission procedure and fee structure shall continue to exist, but only as a temporary measure and an inevitable passing phase until the central government or the state government are able to devise a suitable mechanism and appoint a competent authority in consonance with the observation made here in above. Needless to say, any decision taken by such committee and by the central or the state governments shall be open to the judicial review in accordance with the settled parameters for the exercise of such jurisdiction. So this case, uh, decided by the Supreme Court. Here, the crux of the case is that the Supreme Court has not permitted the reservation policy or the state quota, which was indicated by the Supreme Court in Islamic Academy case. So here, the Supreme Court has not allowed the reservation policies in non-minorities as well as other private educational institutions, professional educational institutions. uh, Reservation policies cannot be enforced or cannot be imposed by the state government in the light of Article 19 clause 1 clause G, because they are also running the occupation or business, but they cannot claim it their right under the word profession. Here, another important provision or guideline which was made by the Apex Court, that was related to the 50% reservation uh, for NRIs. So here, it's my due with all due regards and respect to the Apex Court. I'm uh, I'm not not able to understand. On one hand, the Supreme Court did not allow the reservation for weaker sections or backward classes of the state which were which were meant for catering the needs or catering the local needs of the community, of the society of that particular state. On the other hand, it's the Supreme Court which allowed 50% reservation, 50% reservation for NRIs for earning money by the educational institutions. So is it? I'm sorry to, or I'm not hesitating to comment that is it not the reservation which is based on money and which is meant for money. So although that in our subsequent lecture we'll be we'll be discussing that because of this decision there was a lot of hue and cry in the society, especially amongst the uh, members of the weaker sections, weaker sections, and that's why that it was the then parliament which uh, which uh, which introduced one amendment in the constitution, that is 93rd constitutional amendment, and by 93rd constitutional amendment clause 5 was inserted to article 15 of the constitution, and the rest will be discussed in our next lecture. Please, again, if you are having any doubts, please contact to Mr. Man of A section or Mr. Agarwal from G section, and thank you. We'll be uh, we'll be discussing or we'll be discussing in our subsequent lecture or coming lecture. Thank you. Thank you.